Hi, my name is Raj Garbadian. I'm a real estate attorney. I want to talk to you today about the 5 mistakes landlords make when they're dealing with their tenants. One of the first mistakes people make is that they don't fix problems promptly after being notified by their tenants that there's issues with their property. Whether it's a habitability issue, something broken that needs to be fixed, anything that's the landlord's responsibility to fix, and they're notified from the tenant, they need to make sure they fix it promptly, or that they attempt to fix it promptly and start it within a reasonable amount of time. Usually a reasonable amount of time is considered 30 days, but it depends on a case-by-case basis based on what type of problem it is. But usually if they start, even if they can't fix it within 30 days, but they start to fix it, like they call up somebody, like they call a plumber or they call a roofer, or they make an attempt to get it fixed within 30 days, that's usually sufficient. The second mistake landlords make is that they bring an eviction lawsuit against a tenant within 6 months after they receive a complaint by the tenant. And a complaint is not always about a habitability issue. It could be anything concerning the property. It could be some sort of repair and deduct remedy that they have if they've taken out withheld rent because there was an issue with the property that they spent their own money on, and then they can deduct that from the rent. If the landlord initiates an eviction within 6 months after that, that could be that's an issue because it's considered retaliatory. Another issue that could come up is where the tenant has complained to a public agency, like a city an inspector or an official, about problems with the property. And if the landlord brings a complaint or an eviction lawsuit within 6 months after that complaint is brought, that is considered retaliatory. And also, if the tenants form some sort of tenant union or exercise any right they have, like if they file a lawsuit against the landlord for issues relating to the property, if a landlord brings a lawsuit for eviction within 6 months of filing that of receiving a complaint from the tenant, or receiving a lawsuit or any sort of complaint that the tenant filed, that is considered a per se retaliation. The law considers that as presuming that the landlord is acting to punish the tenant. The landlord doesn't have to just only file for eviction. It could be any kind of reduction in services, like increasing the rent or charging more for electricity or for services, or it could be diminishing services like cutting off electricity or cutting off the water. Any sort of reduction or diminishing of services provided under the lease would be considered retaliatory. The third mistake that landlords make is that they accept rent after the date that the lease has been terminated. So when the landlord serves a notice of termination, whether it's a 3-day notice to pay rent or quit, or whether it's a 30-day notice of termination or 60-day notice of termination, if the tenant sends in rent for the time period after that notice expires and the landlord accepts that rent, then that notice becomes waived and the tenant gets back onto a month-to-month lease agreement. So if the landlord is looking to terminate the tenancy and evict the tenant, they cannot take rent for the period after the notice expires, after the date of termination expires. In commercial cases, a little bit different. If the lease provides that there's no waiver by the landlord if he accepts rent after the date of termination, then it's acceptable in a commercial case. But in a residential case, it's always the case that the landlord cannot accept rent after the date of termination expires. So that's something that residential landlords should always keep in mind. The fourth mistake that landlords make is that they don't treat their tenants equally. They'll provide favors, or they won't enforce certain provisions of the lease. They'll enforce it selectively based on based on certain conditions with the tenant, and maybe past past history with the tenant, or maybe a prior owner used to give breaks to a specific tenant, and then the tenant wants those breaks to be continued with the new ownership. Those should all be avoided, because this can give rise to discrimination or retaliation or bad faith from other tenants. So the landlord should always create a professional management policy concerning all issues with the lease, regarding late charges, parking issues, disruptive conduct, anything relating to the tenancy and the management and the house rules. Those should be set forth in a policy that the management company or the landlord keeps into effect, and always stick to them and don't waver, so you treat everybody equally. You always want to document all warnings to the tenants as well who violate those rental policies, to make sure that everybody is kept aware of the issues, and so if it comes time for you to file an eviction, you've already had prior history and you have documentation regarding those issues, so that it won't become as a surprise when you try to evict the tenant. Fifth one, and I read all these out here: not fixing problems promptly, filing for an eviction within 6 months of a complaint, or filing or exercising the tenant's right, accepting rent after the date of termination, not treating tenants equally, and the fifth one is allowing a security deposit as last month's rent. So as a landlord, you don't want to do this, because if the tenant damages your property and you let the tenant use the security deposit as last month's rent, once the tenant moves out and vacates the unit, if it's damaged, you don't have any recourse. You have to file a lawsuit against the tenant to collect the amount of damages, the amount of money that it will take to fix those damages. So you never want to allow the tenant to use their last month's rent, the security deposit, as their last month's rent. You always want to make sure that they pay completely all the way through the term of their lease, and then after they move out, you can use their security deposit to make any deductions that are needed, and then you can send them the remainder of the deposit if there's anything that was needed after they moved out to their forwarding address. So if you have any questions, you can give us a call, reach out. Our information is on our page or below in the description. Thanks so much.